Kochi. I am also duty bound to welcome each and everyone. Welcome to everyone to this session. Over to the speaker, sir.
Hi, good evening. Rupesh, can you hear me?
Yeah,
Fine, right?
sure.
Yes, sir.
Okay, so thank you for the intro. Now, I've been practicing consumer law, particularly for the more than around 8 years now. And I think I should confess that I represent on both sides. You know, I have a lot of, in our firm, we have a lot of corporate clients. We also have individuals who are on the complainant side. Now, this law was awaited. The new act that we're going to speak was awaited for a long time. We had two bills being lapsed in the parliament, and then later this coming into force. It has come into force on 20th of July this year. That is during this lockdown period, in fact. Initially, that came into force. Then we had the rules coming in. Then we had the consumer e-commerce rules coming in. We also had the mediation rules coming, and I'll come to that in a bit. Now, the earlier act was only a very small act that probably had 31 sections. Now, the new act is a much more broader, a very comprehensive legislation that has around 107 sections in it. So there was a lot of debate as to whether we need such a huge, a comprehensive legislation to address this issue, because a lot of practitioners thought that the small act was good enough to look at the existing issues, because say, for example, e-commerce or looking at the online transactions. The old act has actually expanded by virtue of judicial decisions to look at those issues. So there was a lot of debate as to whether a new act was required. Now, I came across an interesting debate in the parliament. So when the Vice President Venkaiah Naidu once admitted in the parliament, very interestingly, that he was cheated by an an e-commerce company. He ordered a weight loss machine or something, and that was never delivered to him. So if the Vice President of the country could be cheated, then I leave that question open. What is the safety? So this is the push that the government has been trying to bring in, that we need a new legislation that will give a comprehensive perspective into it. So moving ahead, I'd like to start off this discussion with a small question. So this is the question. If anybody could put in their answer in the chat box, I would certainly appreciate that. So this was in the news last year. A natural coconut shell. It's basically the coconut shell that you find in the roads and the streets and in the farms and all. I'm sure people in Kerala and Karnataka would be quite familiar with this. So this was put in Amazon for sale, and the price was around 1,289. So some news said there was something which costed about 3,000 rupees. So my question is it legal? I mean, what is your thought on this? So if somebody could, put their comments on the chat box, that would be really great. So one way of looking at it is say, hey, this is exorbitant. Another way is as when I feel, this is brilliant marketing. So if there are purchasers, if there are customers who are willing to pay for this, then why not sell it? I mean, if the purchaser not selling it, then the price should obviously come down. So what is funny is it says this is actual real coconut, so therefore it might have cracks and imperfections, is what the explanation says. I found it very interesting. So my question is, do you think this is legal? Any thoughts on that? If any of the participants could share it in the chat box. Rupesh, if there's any answer, if you could share it with me, because I can't see any of those. So if there's somebody who thinks that is legal, or what is it? Just tell me a yes or no.
Some two are of the opinion that it is legal.
It is legal. Okay. Okay. Anybody else thinks that this is illegal?
No, only legal. 3 answers legal.
Okay, thank you. I don't think I should wait much. So, okay. Now, the Consumer Protection Act, in fact, looks at it in a different way. Now, if you look at Section 257 Clause I, it says if there is a product which materially misleads the public on the price of the good, and if the price is not that of the regular common use, what you'll find in the general market, it is exorbitant, then it could certainly fall within the purview of an unfair trade. So, this is a debatable point, but then this is how the law looks at it. If you ask me whether it is legal perfectly, I don't know, but then it certainly falls within the purview of unfair trade practice, is what the new Consumer Protection Act looks at it. Okay, so moving ahead now. If you look at the new act and the old act, just to have a bird's eye view of the legislation. Now, moving ahead, I may not be looking at it in a very comprehensive perspective, but I would like to certainly add certain value additions on the topic from the practitioner's perspective. So I may not be going at each sections of it, but we'll just have a look at certain sections which I felt would be relevant. Maybe in the discussion, we can look at other issues as well. So the new act comes up with something called a Central Consumer Protection Authority. That is one thing. Then the consumer, earlier, I'll address the first two issues. Now let's look at the fourth issue. The other issues we'll discuss in the course of this. The pecuniary jurisdiction. So those who are not familiar with consumer courts, it's a 3-tier commission, a system, wherein at the district level, we have the district forum, which is renamed as District Commission in the new act. Then we had the State Commission, which is retained as the State Commission. Every state will have one commission, and each district in your state will have a district forum. And then there is appeal from the district forum to the State Commission, and then you have the National Commission, which is in Delhi. So that's appeal. And there is appeal from the National Commission to the Supreme Court also. So that is one of those rare acts wherein you will find an appellate provision to the Supreme Court directly. Otherwise, we generally use a special leave petition, or we use a writ petition to challenge it before the Supreme Court. I mean, we exercise constitutional power. So this is an appeal provision is provided. Now, the pecuniary jurisdiction, earlier the district forum had up to 20 lakhs. Now it is extended to 1 crore. So 1 crore, so basically we are looking at the value of the products or the services that you're purchased or you're availed. The State Commission it used to be from 20 lakhs to 1 crore. Now it is increased from 1 crore to 10 crore. National, it is above 1 crore earlier, and now it is about 10 crore. So basically, there is a substantial difference, a substantial change in the pecuniary jurisdiction of the 3 forums. Now, e-commerce is one, because as I said earlier, there was no specific provision that addressed e-commerce in the older act, because it was drafted way back in 1980, though there have been amendments, but there was no specific provision. But then there were judgments which said, e-commerce was included within the purview of the act. Now, this is something that is now, as per the new act, they have imposed mediation cells attached with the district forum and the state commissions, wherein parties could be asked by the forum or the forum to go and have a mediation, see if disputes could be settled. So that is also a very progressive point, according to me, wherein we only have mediation cells with the civil courts as of now. So this is one of those tribunals or a quasi-judicial body trying to enforce ADR also into its procedure. So on the other aspects, we'll come to it at a later stage. Now, another question for the crowd. This is something that some of you might have used or seen during the COVID times, a sanitizer which claims to be immunity booster. So, well, I was wondering, because, what confuses me is the usage boosting, sanitizer is obviously we apply on the hands or, somewhere on the surface. So how can it actually boost your immunity is been my doubt. I've been seeing it, in and around in my office, at my home. wherever I go, I see this one. There are a couple of other brands also using the same term. So I was wondering whether, how can a sanitizer actually boost your immunity? So I think you got your point. Now, when I did a Google search, this is a product of the Hindustan Unilever. Now, there have been already complaints, not before the consumer commissions, but before some other okay, there is something called an advertising standard agency. I mean, they have an internal body of the advertisers wherein somebody has already raised a complaint. Now, the Hindustan Unilever is maintaining a stand that it can actually boost immunity. They being a global corporate, a part of a global corporate, they've done studies which prove that it can, boost immunity. But I'm yet curious to know, and I really wish somebody takes it up before the new commission, the new courts, particularly before the authority, because they will have to come and produce their scientific evidence to show how a sanitizer can actually boost your immunity. It can probably ensure your immunity, but then when you say boost your immunity, it means there should be an increase in your immunity. I mean, I'm not coming to conclusions now because the Hindustan Unilever has already given a press statement and so on. So it is a debatable point. But then the point that I want to put forward to particularly to the law students here is, in your daily life, you come across so many instances where you come across products which could be an unfair trade practice or a misleading advertisement. I think consumer courts, forums are the right places where you can take it up. All right. So now this is a news that was widely discussed in a global platform. I'm sure all of you might have heard of Johnson and Johnson. Now, Johnson and Johnson had introduced a hip implant a couple of years back in India, and their product was actually used by around 4,700 patients across India. Now, globally, it was a faulty machine. It had a manufacturing defect. I'm not going to the technicals, but then I was also part of one litigation before the Kerala State Commission, wherein one person in Cochin had challenged it because it was a manufacturing defect. And once it is implanted into your body, it is not difficult to take it. It is not possible to take it back. It becomes a part of your body. And imagine a product having such grievous consequences. Now, in India, if you're on the right side, that is the Indian news. We don't have a structure. So we don't have one body to take it a global concern like this, say a national concern like this. Because we had, 4,700 users. The report says Johnson & Johnson or the government has not been able to trace even the 4,700 patients. So Johnson & Johnson said to the government, government took it up. Government said you'll have to pay 20 lakhs to each patient. They challenged it before the Delhi High Court, and they said, there is no provision for the government to enforce this 20 lakhs. If a person is aggrieved, if a patient is aggrieved, he'll have to go to the individually district commission. So there will be, ideally there should have been 4,700 litigations across India. But, my understanding is only a handful complaints have been filed already. Now, look at what they have paid in United States. They've paid $1 billion already, and the numbers are increasing. Difference in the legislations. Now, this is where the Consumer Protection Authority. Now, this act, the new act, envisages an authority called the Consumer Protection Authority, who can take up actions on behalf of a class of consumers. So you might have heard of the class action suits abroad, and particularly if you watch Hollywood movies, you've seen that. This is a beginning in India where one authority, a governmental authority, can take up actions on behalf of a class of consumers, and the Consumer Protection Authority can be a complainant before the consumer forums, the district forum, the state forum, or the national commissions. So this is a very progressive step as far as Indian legal, the consumer law practice in India is concerned, and primarily looking at these issues. Now, another example that I've often found is often you'll find car manufacturers, recalling certain models, say a 2016 Nissan or a 2017 so vehicle. Now we don't have an authority to look at it from a national perspective, a legal authority. So because if you are using that brand of a car, and if you've not been informed, or if they are not recalling your car, where do you complain? You'll go to consumer court. So what about, because it's the same defect that is upon all categories of cars in the same year. So this authority can actually order the manufacturer, direct the manufacturer to recall the entire products in a particular range. So in a way, I think this is a very progressive step. Now, moving ahead, now some of you might remember this advertisement. It was very common all days when we used to watch cricket more actively, I suppose. So this group, Amrapali group, they went into winding up, is what I understand. They were a builder mostly in North India. Mahendra Singh Dhoni was their brand ambassador. And a lot of complaints came across them. There was cases in the Supreme Court before different forums. Now, a lot of people at that point of time complained that we had doubts about this group, but we invested, we purchased their product because we thought Dhoni was involved, and we thought that was a credible real estate. So a lot of people said it. Some of them even went on to file criminal complaint against Mahendra Singh Dhoni, said Dhoni cheated us, which I don't think is maintainable, of course. But then later, some reports said that Mahendra Singh Dhoni had an investment in this particular company. His wife had a company to which this group had diverted funds, and so he was a potential investor or a partner in them. Now, the Consumer Protection Authority has powers to hold the endorser of a particular brand liable if he was endorsing a wrong advertisement. So that is one. But then the standards are high. Obviously, he should have been known about it, or if he has doubts and if he still went on endorsing them, they cannot take a penal action against him, but they can bar him from endorsing any other product for a couple of years. And subsequent, like if the offense is repeated, then I think they can impose some penalty and all. But then I'm not saying they could be criminally liable, because that's too far-fetched an argument. But I feel this is a very progressive step. This is obviously, you might have heard of these kind of laws abroad, but I think this will have its own repercussions in certain sectors like real estate, which is very volatile, and in which credibility of the builder is very important. So I think that's a very progressive step again. Now, some of you might have received WhatsApp messages. I did receive in some of the lawyers group that I'm part of, that the new Consumer Protection Act avoids doctors, medical professionals from the purview of the new Consumer Protection Act. Now, which according to me is false. Now, because section 2 clause 42 of the new act defines service. So it says service means service of any description which is made available to potential users and includes but not limited to. So I'll pause here for a moment. So what really happened is, before the current bill, there was another bill, I think it was 2018 Consumer Protection Bill, which eventually lapsed, and then the new bill was introduced. So the 2018 bill had, when it defined services, specifically excluded healthcare from services. Okay. Later there was a lot of discussion, and when the new bill was introduced, in the earlier bill, healthcare was included, and when the new bill was introduced, healthcare was excluded. So the medical professional said that the parliament didn't want healthcare to be a part of service within the purview of Consumer Protection Act, and hence we were avoided. Okay, so this led to a lot of discussion. But then my view is that the view propagated by IMA is wrong, because the law as of now, or the definition of service as of now, is exactly similar, except for one or two additions there and there with the old act. Now, in the old act also, healthcare is not specifically mentioned as service. It was subsequently by the Supreme Court in VP Shanta's case, it is IMA versus VP Shanta 1996 judgment, wherein the Supreme Court said that healthcare also fall within the purview of Consumer Protection Act. So applying the same logic, I think medical care or healthcare professionals also fall within the purview of Consumer Protection Act, because the act uses the same, means service of any description, and then it says includes but not limited to. So it has specifically included certain sections like banking, financing, insurance, transport, but it obviously says it is not limited to. So I think the judgment of VP Shanda still holds ground, and hence for the same reason, because there are certain other sections wherein there has been specific exclusion. So if medical profession was to be excluded by the parliament, they ought to have done it. I think medical professionals also fall within the purview of Consumer Protection Act. So if medical professionals fall within the purview, then obviously lawyers and chartered accountants and all those professions who have not been specifically mentioned, they also fall within the purview of the Consumer Protection Act. Just give me a second. Okay. Now, moving ahead, this is one very interesting and a very innovative concept that has been introduced in the new act. Section 2, clause 46 introduces a concept called unfair contracts. Now, only a state commission and the national commission can declare an act, or sorry, a particular contract to be unfair. Now look at this. This is how defined. So just excessive security deposit and contract which requires excessive security deposits, a contract which imposes wholly disappropriation and to the loss, refusing to accept early repayment, termination, unilateral termination, or imposes any unreasonable charge or obligation. So I have a question for the crowd. Can somebody tell me which sector is it primarily looking at? So I feel this particular, I mean, it obviously applies to all sectors, but I primarily feel that this is intending at a particular sector. So can somebody put in the chat box? Which sector do you think this section is looking at? Rupesh, do we have some answers?
Yes, sir. Banking, insurance, loan.
Okay,
Some
good.
of them wrote
Good,
banking
good.
and construction.
Okay. So I think it's primarily looking at banking, banking and insurance for that matter. You're right, but mostly at banking. So so if you look at all of them, excessive security deposit, early repayment, I mean prepayment issues, early termination, unreasonable charge. I think it's primarily looking at banking. So thank you for that response. So this is a very interesting aspect also, because the act is actually saying that the courts could actually, declare a particular unfair contract as unfair. So if you look at banks, so for example, X bank's contract is declared unfair by one court. Most often it is a replica, right? Because they have standard contracts, so it forms binding on all the contracts that the bank has entered into, is what I feel. So, I mean, if it is a replica, they have standard contracts. So in that way, I don't know, I mean, how courts are going to look at it, but I think it's going to be a very interesting development. And obviously, the law needs to evolve because it's a new section, a new concept it is involved, but definitely a progressive one. Now, I think in the beginning I said that the new act primarily looks at settling of disputes. Now, it says every district forum, state commission, and national commission needs to have a panel of mediators attached to it. There will be a panel which will be selected There could be, so if the parties either can opt that we want mediation, or if the parties are not opted, the courts can also ask, but obviously they need, since it is ADR, they need to require the permission of the parties. So the government has actually brought in a mediation rules also along with the act, which is available on the government side, which I found very positive. But then the only factors, it says the fee is to be paid by the parties, so which is very different from the existing civil, the original side practice that we have, where we, I mean, at least in Kerala where I practice, mediation is free. It is not paid by the parties. And if the mediation is successful, then the mediator gets full fees. And if the mediation is not successful, then the mediator gets only half fees. So very interesting concept. I don't know, but I really hope and I wish that the mediators don't push the parties to settle, because they, because the fees is also dependent on the success rate. So I have certain concerns on that. But I think with the right kind of people in the mediation panel, I don't think that's going to be an issue. But if merit is being compromised in selection of mediation panel with forums, then that might turn out to be an even bigger issue in the days to come. But my understanding is, see, in my practice, I've represented a lot of corporates. See, a lot of corporates these days are willing to settle their disputes on the first posting of the case, because, but it's just that the consumer, may not be accepted. He might be furious. He might be looking at very emotional point of view. But a practical mediator who can cool down, who can create a good atmosphere for discussion, I think can help to settle a lot of disputes in the first posting, and that will help us to reduce the pendency of cases in consumer courts in a big way. Now, I'm not sure of the situation in other states, but in Kerala, the pendency is huge for multiple reasons. Today morning, I had a case in the forum. It is a case that was filed in 2016. For multiple reasons, it got delayed. But then we have cases in Ernakulam forum, where I primarily practice, of 2015, 16, and 17 pending. Number one, the consumer courts in Kerala, at least, are not controlled by the High Court. That doesn't fall within the regular judicial perspective. Framework. It's managed by the government department. The appointments are done by them. The funds are allotted by them. The staff who are assigned to the consumer courts are also not, the regular court staff. They are people from from a department who wish to come, or who are not really happy working there. So I think that is one issue where this new act also fails, because I don't think that kind of monitoring or the government, I really wish the entire forums were also brought within the purview of the regular judicial, the lower judicial system of each of our states. But I don't think this act has not made any progress towards it. So that still continues to be an issue. So addressing on the mediation part, it's a very progressive step, because I can't recollect any other law wherein a mediation panel is attached with a tribunal, and so that kind of a mediation structure as such. Probably the courts might forward it to mediators of their choice, but a definite structure with a mediation, with a court structure, with a quasi-judicial body, I think it's the first step, at least in my knowledge, and this will be also a very progressive step. But then the key is who are selected as mediators, what are their qualifications, what is their merits, and how trained are them. So I think that's very important, because mediation is essentially also a skill, like lawyering, wherein you need to have a different set of skill set to bring the parties to a mediation agreement. All right, so moving ahead. Okay, so here are some of the practitioners' perspective that I wish to address. Number one, the new law, the earlier law, the 1986 Act says only persons qualified to be district judges. Okay. Only persons qualified to be district judges could be presiding officers of the district forum. So when I say qualified to be district judges, they're either district judges or they're lawyers with a particular X number of years of practice. So that particular clause is being taken off. So there is no restriction as to who could be a presiding officer in a district forum. Obviously, the members earlier also didn't have, but then the president of the forum, that's the main person, he ought to have been either of a district judge or a lawyer. Now, this can have far-reaching repercussions because look at the previous section that we're speaking of, unfair contracts. So to look at a particular contract, appreciate the evidence, see whether this contract fall within the the walls of law, or whether it is an unfair contract as such. My understanding or my respectable view is that requires a judicial mind, that requires a legal training, that requires an application of mind, like the way we are trained in law schools and court. That requires practice of law. Essentially, I would say that any person from an outside world, probably from bureaucracy, may not be able to appreciate it like the way lawyers do. A very even important fact, as I said, doctor. So we'll have extremely serious medical negligence cases coming up before commissions, because now the limit is 1 crore before the district forum. So where we'll have to examine doctors, we'll have to examine nurses, witness, appreciate it in the light of the Supreme Court judgments as to what is the liability of doctors. In those scenarios, a person who's not legally qualified presiding over the bench, I think is going to be really bad, because I have my own apprehensions as to how that is going to practice. I really wish that the legislature has a rethink about it, and the presiding officer ought to be a person of a legal training, is what I feel, because essentially it's a forum, but it is exercising powers. It's obviously a quasi-judicial body, but then the volume of the matters that comes before it is huge. So that's what I feel. Now, section 34 2D. Now, this is very interesting. Now, it says complaint can be filed where the complainant resides or personally works for gain. Now, this amendment, in fact, answers a lot of questions that practitioners have been facing for over a period of time, because, and this is very revolutionary also, because if you look at Civil Procedure Code, even the Civil Procedure Code doesn't permit you do this. The Civil Procedure Code doesn't permit the suit to be filed where the plaintiff resides. It usually is filed there because the cause of action is also lying there. But the place where the plaintiff resides is not a place of cause of, doesn't invite jurisdiction in a Civil Procedure Code. So now this can looked at in different ways. Number one, say for example, an e-commerce transaction. Earlier, there used to be a lot of doubt whether, I am in Cochin, my bank is in, say, Delhi, I'm paying something from Agra, it is delivered somewhere else. So, where is the cause of action? So can I file it in Cochin? Because it's just that I'm there, my bank is not there, the transaction happened online. So, there were a lot of debates on this. Now that is answered. This new act says the complainant can be filed where the complainant resides or personally works for gain. Now, in another discussion last week, some of them were raising a question whether when you say complainant resides or personally works for gain, will it lead to forum shopping? I don't know. I think it might. Say, for example, it was a doctor's forum where, I was watching a discussion. So a doctor was addressing, so I'm having a small clinic in Cochin, for example. A patient, say Kerala being a tourist hub, say somebody comes from Delhi, he does a small treatment here. So for example, a dentist, he does a dental clinic, for example, cleaning, for example, and there is something, he has an issue. He goes back to Delhi, he files a case there, Delhi. So the doctor is asking, the case actually what led to the dispute has no connection with Cochin, right? So sorry, it has no connection with Delhi, because the doctor is here, the patient came here, the surgery happened here, everything happened here. But then it is filed in Delhi. So he'll have to go to Delhi and defend it. Looks slightly arbitrary. But I think this answers a lot of questions, and it is a pro-consumer viewpoint. But personally works for gain could have been avoided, wherein probably he could be working, say, not in Delhi, that patient, he might be working somewhere in Northeast. So and then the complaint again goes to Northeast. So I think it might lead to forum shopping, but then eventually in amendments like this, we can look at it, analyze the practical implications only after a couple of years is what I feel. Now, Section 36 says admissibility of a complaint to be decided within 21 days from the date of filing. If not, it is deemed to be admitted. Now, what is for those who have not into active practice or law students, admissibility is the initial stage of any complaint where the courts looks at a particular complaint and see whether it is maintainable. So in a consumer court, the main contention that the opposite parties raise is that this complaint is not maintainable. Say, for example, it could be the jurisdiction that we discussed, or it could say there is a commercial, it was purchased or the service was availed for a commercial purpose. So that is very important. Now, the problem with 21 days is, I'm okay with a number of days being fixed so that it is not delayed. Most often, the opposite party might not have appeared on the 21st day of filing of complaint. Say, for example, a complaint is filed in the January here. Usual case, a notice to be sent from the court. It comes back to court. It goes back to Delhi. So, for example, the opposite party is in Delhi, and then they appear. It might take a minimum of a month. So before 21st, in 21 days, even the opposite party will not be in the court to answer the maintainability fact. So I think in that sense, it is arbitrary. And I'm sure some of them might take it up before the appropriate courts, challenging the constitutional validity on the arbitrary part. Because the courts are going to decide on the maintainability of the complaint without even hearing the other side. So that's going to be the practical implication of this 21 days. And this is a case of poor, legislative drafting is what I feel. So I think some of them might take it up because in a lot of cases, not all complainants are, fair gentlemen. They might hide facts from the court, not produce the entire documents. We see that quite often. And then if the maintainability is deemed to be admitted within 21 days, it can lead to a lot of litigations. I can vouch for that. So I think this 21 days limit is unfair and arbitrary is what I feel from a very practical side. Okay. Section 40 and 50, power to review. 40 is for the district forum and 50 is for the state commission. It has been a long-standing demand of practitioners of consumer forum that they didn't have the power to review their own orders. So, but then it says error apparent on the face of record. That's a usage that we find in the civil procedure code itself. But we know that it is not just used for error apparent, it's used for anything and everything. But then a court might commit mistakes, particularly when you don't have a person of a legally trained mind presiding it. So that's the importance of what I said earlier. Somebody has raised hands. Rupesh, if you can, whoever has raised hands, we'll answer your questions at a later stage. So when there is a review power, if the courts don't have a review power, I think their hands are tied and they're in a crippled state. So I think this is a very progressive thing from a very practical point of view. Yes, this is needed for any forum because the courts might look at it. Say sometimes the one side might not have reached court on a particular day. Then that doesn't mean that an illegality needs to be done because otherwise they will have to take it in appeal, get it remanded back. So it takes a lot of time. So if the courts can review then and there, I think that's a very progressive viewpoint. And from a practical point of view, that was much needed. The 1986 Act, the courts, the forums didn't have the power to review its own powers. Its own orders. Now, Section 71. Now, it is not just enough that you get an order, you should be also able to enforce it, right? So earlier, there were two options. There was a civil remedy and there was a criminal remedy. Now, the civil remedy was that you file a complaint and if the opposite party had a property, you can attach, say, for example, they owe you by virtue of the order, say 10 lakh rupees. So you can attach their property, sell it, and you can encash that 10 lakh rupees. Now, earlier the process was the forum used to write to the district collector, who writes to the RDO. he writes to the village officer. The village officer gets a report. Then he gets back to the district collector, sorry, the RDO. The RDO gets back to district collector. District gets back to, writes back to the forum stating that he has this sense of lands in this village in this part of the country or this part of the state. And then the court will again, start the procedure of attaching the land. And so, I mean, by the time you would have understood how much time can it actually take. Now that is being replicated by the powers of a civil court under Order 21, which I think is very progressive. The court can straight away go and attach the property, take the measures provided under the Civil Procedure Code. So in that sense, I think that will make the enforcement of orders much, much faster, and it empowers the courts as well. Now, Section 26 speaks about vexatious and frivolous litigation. It was available in the earlier act. I think there was a punishment of 10,000 rupees, if not mistaken. Yeah, the courts could, if the district forum or the forums, if at the end of the trial, if they find out that this was a frivolous litigation, they could enforce 10,000 rupees. That powers have been taken off. But then there is also, a counter argument that that the power to impose cost is inherent in any court. So even if there is no power of this, even if there is no provision of this kind, the courts could actually go on and impose, cost or compensation if it finds frivolous. So I have my own doubts on that, but I think it's eventually has to be seen, because earlier, even if they imposed a cost frivolous litigation, there was a limit of 10,000 rupees. Now there is no limit. So that's a positive way of looking at it from another perspective. Okay. Now, Section 3 and Section 100 of the new Act. Now, what does it say? It says it is in addition, the provision of consumer protection. It's general principle. So, for example, you've defaulted a particular bank loan, right? And the banks have proceeded under arbitration. Now, you are maintaining a stand that the banks have not disclosed about, or you used to, for example, you're maintaining the stand that the bank agreement was unfair, right? So the fact that they have started an arbitration against you is no legal bar for you to approach the consumer court and say they can proceed with arbitration, but my agreement was unfair. So, so what I mean to say that just the fact that the parties have another litigation, for example, even in civil courts. So often we find, parties filing rendition of accounts, because that's not something the civil courts civil courts do. So you can parallelly have a civil court litigation and a consumer court between the same parties, sometimes on the same cause of action, but on different reliefs, because what you essentially look in a consumer court is where there is an deficiency of service, whether there's been an unfair trade practice, on and so forth, within the purview of Consumer Protection Act. So it could be a civil dispute that is running parallelly, or it could be even an arbitration proceeding that's running parallelly. Now, this is my view on Section 2, Clause 7. Okay, so Section 2, Clause 7 of the new Act defines, it speaks about it defines consumer. Now, I'm not going to the definition of consumer here, but then only one exception for a consumer not to file before a consumer forum is when he had availed the service, he already bought the product for a commercial purpose. Now, the commercial purpose is not defined in the Act. That has been developed over years by courts. A common example that I find, is an old proposition which says, if you can, it says like this: commercial purpose. Okay, so the explanation says the commercial purpose does not include a person who used the products or goods used by him exclusively for the purpose of earning his livelihood by means of self-employment. So this is what it is. So if a person has one taxi, and if he drives it, he's doing it for self-employment. Now, if he employs 25 drivers, and if he's running a taxi service, then the courts have said that that's not, he's not a consumer because he's doing it for a commercial purpose. So earlier there was an issue. So some of you might know the insurance companies had something called ULIPs, which is the insurance product linked with the shares. Because the value of the shares keep on changing, and it is you expect a profit also along with your insurance protection. Now the Supreme Court has said that when it comes to ULIPs, you cannot file before the consumer courts because it's essentially you don't fall within a consumer perspective because there's a commercial purpose involved. Now, I really wish this was an opportunity because since we are looking at a new legislation, a very comprehensive legislation, there was a lot of confusion. For example, I had looked at one case wherein he availed a software which was for a commercial purpose, but then there was a warranty given. So based on a Supreme Court judgment, again, the court said the warranty or the AMC is not commercial, but the product is commercial. I mean, there are contradicting views on this, but that's taken. Now, another example of a case that I had represented was somebody bought a car. So we were for the car manufacturer. Now, the RC book or the vehicle registration details had the vehicle being registered in the name of the his own private limited company, but the car was essentially used by him because it was a hatchback. No, it was a sedan. So obviously you cannot use it for the commercial purpose or carrying on goods. He was using it. But then the court took a view that since the car was registered in the name of the company, it was essentially for a commercial purpose. You cannot count a private limited company as a consumer. So there are decisions either ways, but then there was a lot of confusion into this. So I think this was an opportunity for the legislature to clarify as to what exactly is commercial purpose. Now, section 41 and 51 speaks about appeal provisions. Now, appeal provisions is where you challenge a particular order. So as I said, if you have an order against you in the district forum, you challenge it before the state commission. From there, you challenge it before the national commission. Now, earlier it used to be, there was a limit for the fee that you pay, the court fee that you pay. From district forum to state commission, it used to be 25,000. So it says 50% of your decree amount or 25,000, whichever is less. So there was a maximum limit of 25,000. Okay, from state commission to national commission, it was 35,000. So that limit has been taken off. So it just plainly says 50%. It appeared like a very, it looks like, oh, okay, so opposite parties may not go on appeal. But then it has a slight amount of arbitrariness in this because, see, look at the limit of the district forum. So district forum can pass an award, say, of 1 crore, right? So if it is 90 lakhs, say the decree amount is 90 lakhs or the order is 90 lakhs and somebody wants to file an appeal, he will have to straight away pay 45 lakhs as just court fee. And if so I think that's arbitrary because we're not always looking at huge corporates, alone. It might be a seller of a shop. It might be a small, an SME. It could be a small clinic, a hospital, a doctor running a clinic, where it is his own right to file an appeal, and imposing such huge cost on as appellate fee. I personally feel is very arbitrary because it's, as we say, it's not just justice, justice should also be seen to be done. So in that perspective, I think there should have been a limit. Probably 25,000 and 35,000 could have been revised, but fixing no limit on the appellate court fee just says 50%. And then, extending the jurisdiction, the pecuniary jurisdiction, I think is very arbitrary is what I feel. Just give me a second. Okay, so Rupesh, how much time is left? Rupesh, how much time is left? I mean, like, are we running short of time?
No, sir, you can continue.
Okay, no, I'm almost done. So I just want to point out a couple of things as well before we move ahead. Now, subsequent to the coming into force of the Act, There have been an e-commerce guidelines also. So basically it looks at e-commerce entities. It's two. One is, we don't have a slide for that. One is inventory e-commerce entity and then marketplace e-commerce entity. So there have been, I think it's an effect of learning. Probably you guys can look at it. E-commerce doesn't, though the act says e-commerce fall within it, and the act imposes that you can even file a complaint online. So that is permitted. And any complaint less than 5 lakhs, there is no court fee. So that is also a very progressive steps. But then when it comes to e-commerce, the code, I mean, the rule says it's a different set of rules under the same act. It says it is all about self-regulation. So the e-commerce entity needs to have a grievance officer with whom you can raise a complaint, and he needs to respond within 48 hours and then try to solve the complaint within 1 month. So that's how it is. And then a lot of conditions, the usual things like there cannot be any refund and so on. So, but then I have my own doubts whether, the courts can actually extend the jurisdiction to that. It's something that needs to get evolved in the course of time. So I think I'm almost done. So just wish to end it on a lighter note. I mean, I want to explain a cartoon, but then it's all about caveat emptor. It's all about the consumers being precautious, the consumers being aware of their rights, and being careful about what they do. When they're acting as consumers. I mean, caveat emptor is obviously the principle to put forward. Thank you. Thank you so much. I feel free to put forward your questions.
Yes. Thanks, Jitin, for your informative and intrusive speech. And I thank Rupesh at this juncture for his wonderful welcome note. Now, it's time for discussion as many questions have been put forward by the participants. And I request Aishwarya, student, Oxford College of Law, to kindly share the questions with the speaker.
Firstly, thank you, sir, for this informative seminar. The first question is raised by Tanvi Agarwal. Her question is, can court refer a case instituted as class action for mediation since larger interest is involved in such a case?
No, there's no provision of the courts referring a case because see, class action is not when the courts determine whether there is a class action. It is when obviously the parties are free to open. See, the Consumer Protection, the authority can suo moto take I spoke about the Consumer Protection Authority. They can suo moto take a complaint, or you can also file a complaint. So you can directly approach the authority, and it is only through the authority that you can actually move a class suit. The other one is available before the Civil Procedure Code. So I don't, the courts referring for a class action, no, the courts don't have a referral power under the Consumer Protection Act. Sorry.
Sir, good evening. This is Gopi from Oxford College of Law. I have a question. If a consumer buys a product from an assembling unit, right, and which uses the reputed manufacturing company product, right? If there is a damage or if there is any, defect in the product which he buys from the assembly unit, the assembly unit is not a dealer. Okay, he has nothing to do with the manufacturing company. But in this kind of a case, right, this consumer, whom should he claim for the damage or claim for the, such defect in the product?
Okay. In a typical manner, I say my answer would be it depends. Let me explain. Depends on what is the defect and what is. See, if your defect, if your complaint is regarding the part of that. Say for example, let's look at a computer, all right? So if the monitor is of say a reputed brand, and if there is a defect with the monitor, then obviously the manufacturer is liable. But if the defect is regarding the assembling process, then obviously the manufacturer is not liable. And number one. Number two, the consumer, that's what I entered, the caveat emptor principle comes into play. When you are buying a product, even from an assembler, you ought to get the warranty for the product from the manufacturer. So if it is devoid of warranty, then you are taking a, because if the act is the manufacturer is not liable in violation of warranty obligations. So you ought to look into whether the product that is assembled, if does it loses its warranty just because it is assembled. If so, you shouldn't, because obviously your liability will end with the assembler. But if the warranty is there, then obviously you can look at the manufacturer as well.
Thank you.
You're welcome.
Aishwarya, any more questions?
No, ma'am.